Let's talk about what happens when a simple neighborhood dispute over something like a carport actually ends up in court. We're going to break down a real-life case where one homeowner decided to take on their HOA, and believe it or not, the entire outcome hinged on the meaning of a single word. Okay, so let me ask you something. Imagine your neighbor builds something and you are convinced it breaks the community rules. You complain, right? But what if nothing happens? How far are you willing to go? Well, that's the exact situation one homeowner found herself in. All right, let's dive into the details. The case is Delores Harrold versus the Prescott Country Club Property Owner Association. Yep, it's a classic story. One person deciding they're going to take on the entire HOA. So here's the play-by-play. Back in February 2007, the HOA's Architectural Committee gives the thumbs up to a neighbor's carport. By June, Ms. Harrold is claiming something improper happened. And then just 2 months later, in August, bam, she files a formal legal petition. This thing escalated, and it escalated fast. So what was her big complaint? It wasn't really about the carport itself. The core of her argument was that her HOA had broken its own rules by illegally granting a variance to approve it. And that one word, variance, is the pivot point for this entire case. So this is where the battle lines are drawn. You've got Miss Harrold, the homeowner, on one side, and the HOA on the other. Let's really break down what each of them were arguing. Miss Harrold's claim was pretty straightforward. She said, look, the HOA's own rulebook doesn't give it the power to grant this kind of variance for a carport. But the HOA's defense? It was actually even simpler. They basically said, we didn't grant a variance because we didn't need to. Why? Because our rules don't say you can't have a carport. You know, it's kind of wild when you think about it. This entire case, all the time, the lawyers, the fees, it all came down to how you define and apply that one word. A classic and very, very costly misunderstanding. So what in the world is a variance, legally speaking? Well, it's an official exception. It's when the rules clearly say you are not allowed to do this, but the board gives you a special hall pass to do it anyway. The key is it's a deviation from a specific written rule. And this right here gets to the absolute heart of the HOA's defense. Their logic was, hey, you can only grant an exception if there's a rule to make an exception from. Since their documents never said no carports, approving one wasn't a special exception. It was just a normal architectural approval, which they were totally allowed to do. Okay, so you've got two completely different ways of looking at the exact same event. It was all going to come down to an administrative law judge to make the final call. Let's see how the court saw it. Now, before we even get to the juicy details, you have to understand this major legal hurdle Ms. Harrold was facing. It's called the burden of proof. What that means is the responsibility was on her. She couldn't just accuse them. She had to prove, with actual, credible evidence, that the HOA broke the rules. And, well, when the judge actually dug into the evidence, Ms. Harrold's case just fell apart. First, the judge found the committee absolutely had the authority to approve the request. Second, the HOA rules didn't say anything about prohibiting carports. Third, and this is a big one, it turns out other carports were already in the neighborhood. And finally, the nail in the coffin, she couldn't show any credible evidence that a variance was even granted in the first place. So the final decision was simple and direct. The judge sided with the HOA. Because the approval wasn't a variance, the HOA had done nothing wrong. They just followed their own procedures. Case closed. And for Ms. Harrold, this wasn't just losing an argument on paper. She was out the $550 she paid just to file the case. That is a very costly misunderstanding. Ouch. Okay, so what's the big takeaway here? What can we all learn from this very specific, kind of small-scale legal drama about a single carport? Well, first, it's really important to realize that most of these disputes never even get this far. A lot of the time, the person complaining just withdraws, or the two sides work out a settlement. Sometimes the case just gets dismissed. A formal hearing with a judge is usually the last and most expensive resort. But here is the biggest lesson of all. Your feelings about what should be a rule don't matter in court. A fight with your HOA is a legal fight, period. And winning or losing boils down to one thing and one thing only. What is written word for word in those governing documents? Which kind of leaves us with one final question to think about. If you live in an HOA, be honest, when was the last time you actually read the rulebook? Are you absolutely sure you know what it says? Because as this case shows, what you think the rules are and what they actually are can be two very different and sometimes very expensive things.